everyone, and a special welcome to those who enjoy exploring the bridges between law, markets, and society. This is episode 17 of The Global Lawyer, and I'm Marina, your host. Before we dive in, a quick note. November is a very special month for us at the São Paulo Lawyers Institute. And this year we are celebrating its 151st anniversary. So it feels just right to mark this moment with a conversation that reflects IASP's long tradition of dialogue, innovation, and excellence in the legal profession. I'm truly delighted to have with us Professor Luciano Timm, a renowned legal scholar and a leading voice in Brazil's legal and academic circles. And I want to say that something that feels especially true about our guest. When we talk about global law or a global lawyer, we usually think in terms of geography, right? Borders, countries, jurisdictions. But Professor Timm embodies a much broader, richer meaning of global. His work treats the law as part of our social fabric, something that only reaches its full potential when it's understood alongside other fields, from economics to behavioral sciences. He approaches contracts not just as legal instruments, but as market tools that should work efficiently, fairly, and in step with how people and businesses actually behave. It is an interdisciplinary lens that expands what we mean by global and, frankly, expands how we think about the law itself. Professor Timm plays a huge role in bringing law and economics into the mainstream here in Brazil. And for those who don't know his background, it is truly impressive. He's a former national official of consumer defense, a postdoctoral and visiting scholar fellow in law, economics, and business at UC Berkeley. He holds a doctorate in business law and a master's in private law, both from the Federal University of Rio Grande do Sul, an LL.M in international economic law from the University of Warwick in England. He is a researcher at USP and at INSPER, and also a former vice president of the Brazilian Arbitration Committee, CBAR, and president of the Brazilian Law and Economics Association, besides, of course, being a long-standing legal professor. But what really stands out is the way he works. Professor Timm has been at the center of some of the most high-stake disputes in the country, and he sets the bar incredibly high when it comes to legal strategy. He approaches commercial contracts with a unique mix of economic sophistication and practical legal insight, the kind of combination that genuinely moves the needle for businesses. His arbitration work, especially in corporate contract and construction disputes, only reinforces how respected he is as a hands-on, trusted strategist. And something I find fascinating, personally fascinating, is that he was one of the very first Brazilian scholars to really embrace and advance the academic and empirical approach of law and economics, which not only shapes how we think about legal theory, but also how those ideas actually influence real business decisions and regulatory environments. As someone whose career I truly admire, I'm especially struck by how easily he moves between complex academic debates and the very practical demands of the real world. He blends theory with lived experience in a way that's incredibly rare and incredibly inspiring. Professor Timm, thank you so much for being here. It is a real pleasure to have you on The Global Lawyer.
Hi, Marina, and to all of those who are watching and listening to us. It's a pleasure to be here, and I'm honored to be interviewed at your podcast, especially considering IASP.
That's great. So, Professor, I'm curious, what first drew you to study economics? And how did that interest eventually lead you to law? I imagine that that background gave you a sharp lens to see how contract law is often viewed by the judiciary, even in cases involving sophisticated business players. So you work, in fact, your work draws a strong contrast between the paternalistic tradition in contract law, centered on distributive justice and state intervention, and the law and economics approach that focuses on market efficiency, right? So from your perspective, what are the main risks or unintended consequences of holding on to that paternalistic mindset in contract relations, especially considering how recent case law has evolved here in Brazil?
Well, I think it's quite fair the way you describe my work in terms of combining economic and psychological tools with law. I think legal doctrine is relevant, but not as relevant, or should not be as relevant as it is considered in Brazil. Definitely is not the same way it's seen in the US and in England, I guess, as well. And I think we should analyze the curriculum of the law faculties in Brazil and give more room to economics, psychology, which are human sciences, like humanities, right? And I think law or legal theory would benefit from that. I guess North Americans, they have an advantage because law is a postgraduate course, so they need to know something before they enter the law school. So it's an advantage that someone that would work with IP would have a background on engineering. Those who are working with regulation and antitrust would have background in economics, etc. Right? And those who work with psychology might have background in psychology. Those who work in constitutional law might have background in economics or political science. So they have a more connection to reality. That's the main problem of legal scholarship in Brazil. Too much dogmatic, too much, not related to the practice, no tools to measure reality, no empirical work, let's say. So if we apply this, you asked me about what my first contact with economics was. I entered the economics school undergrad. So as if I were in the US, my major, let's say, would be in economics, or minor in economics and major in law. Maybe it's more accurate to say that.
Now, not at the time you entered. Okay.
Yeah. I mean,
your first choice was for economics.
Yeah. I mean, you asked me how I came up with this. My mom and dad, they're both economists.
Oh.
So I had, let's say, an influence that was not direct. They never told me that I should take economics, but
it probably had some.
Some influence, but the most direct influence in my choice was that I was good at math and good at history, which is something that is unusual in high school, right? Some people would be, of course, I had people that were better than me in math, So they became engineers or physicists, but I was good enough. I could be, or I could have been an engineer, and I considered that, but I thought that economics is the compromise between history and math. Yeah, like
it is placed in the center of it.
It's like, not humanities purely, not purely blah blah blah, but also not math like engineers. So I thought that, and I thought like in individualist standpoint, like I could perform better, because if I were in the path of engineer, I would have people better than me.
I see.
And then I wouldn't have any strength because it wouldn't work like the
So
history of engineering.
You are doing an economic analysis of your
I
career
did
choice.
in a way, but then since I decided in favor of economics, I thought that I should put an alternative. Like many people, they would make the exams for the public and the private, right? At that time, there were only two, basically, in Porto Alegre, the Federal and the Católica. And I think it's there's a presumption, not confirmed by facts, that the public train better the students, but it's how the way trademark goes, brands. So I put my first choice economics at the federal, and I thought that I should put another thing at Católica. Then and actually for the first time, Católica de Chile, a private university, surpassed USP as the best university in Latin America. So yeah. So anyway, I went to Católica for I put my choice was law in the Católica and at the Católica, and then I passed both. I didn't know which one I should. Of course, I thought I passed the most difficult one in theory, that is the public, and my parents wouldn't need to pay. But then I thought that it was a pity not to see how law would work, and then I took both. But I was a very good student at economics school, in law as well. But I let's say that I had some gifted for I was gifted for economics, I would say, that I would understand easily, maybe because you learn. You could learn at home. I could see that my colleagues in law, that their parents were judges or lawyers, they know from home, right? And for me, was kind of abstract. And but then let's say that the economy helped me to choose, because at that time law offered much better positions than economics in Porto Alegre. I think. Yeah. I think if I were in São Paulo nowadays, it would be different. I think economics offer a lot of opportunities in São Paulo, and I think it's not by accident that like some economic schools in São Paulo are quite challenging to pass the exams and being admitted. I would say that I think from a scientific standpoint, economics is much stronger than law nowadays, and could give tools to do different things comparing to law, because law, it's only dogmatics. So in economics, they learn statistics. They learn nowadays they are programming.
Yes.
So I think it's a more sophisticated course. The point is, at my time, law offered more opportunities, and also I think law is interesting not in theory but in practice. So I think I have this joke that economics is better in theory, and law is more interesting in practice.
Right. You're right.
So I think economists, they don't have enough problems to solve, and law has a lot. So, if you use economics to solve legal issues, is a quite good combination. Not leaving aside the dogmatics, I think it's still relevant, but I think the future of legal science is to combine with other areas.
Right. Yes. Yes. And so I thought you would have chosen first economics, and then afterwards you would opt for law. So the examination, so the admissions exam for university, they were simultaneous. So
Yeah.
you did both, and then you got to enter in both, and then
Yeah.
so you kept on with both courses.
For 3 years, I
For
just
3. Okay.
I left economics in basically the last year, but let's say that I fulfill half of the credits of economics, because my idea was to finish law first because the market was better,
Right.
and then
I see.
finish economics.
But when you were at the beginning of your studies, did you, from the very outset, did you realize any connection, any common ground between law and economics at that early point in your studies, or this is something that grew with time?
I thought I could see my colleagues and my professors don't or didn't. But at that time we had inflation, right? So there were all the consequences of inflation in contracts. And I thought that, and there were those monetary adjustment indexes. So that was the most obvious connection to me.
Right.
At that time, when I entered the law school, we didn't, it's crazy, but we didn't have CAD as the way we have today. There was CAD, but there wasn't, because, CAD as we know it was recreated in 1994. So there was that's another point. If there were CAD at that time, it could offer me, some inspiration.
Yes, because antitrust law is really close to the economic analysis. How the very antitrust law.
Yeah, I have this joke that in some law schools in Brazil, no, they teach anti-economics law because they don't understand economics. But in general, in the rest of the world, especially in the US, UK, yes, and it was so true because I took microeconomics. Macroeconomic, micro and micro.
Micro and macro,
Yeah. And then I went to England for the LL.M, and I took the competition law class, and I was performing very well, the course, and they thought that I was genius, but that's because I took economics and
of course you had the whole basis that you had.
yeah, and for me it was, was that was another moment I could see a great connection. But yeah, during the undergrad, in both law and economics, well, there was a course, an introduction to law in economics, and there was an introduction to economics
in law.
In law. So there were signs, but it was not obvious. And at that time, there was no such an incentive. People thought that I was in doubt, in job interviews, but what do you really want?
They didn't see the value.
They didn't
in the
see the
connection,
value.
in the interdisciplinary. Which is
And
today, which is
much different, right? And the reality today is different. We have the Brazilian Law and Economics Association that
that you presided over, you headed.
That exists for 17 years. We had an economist at the Supreme Court. So we have CAGI, we have regulation. So it's different, but at that time was not that clear, and that's why I suspended economics to come back in the future. But then life took me to another path, and things reconnected later on in my career by accident. So was not planned. But of course, the fact that I studied economics as an undergrad course makes or open my eyes to law and economics. And then you asked me about the studies that I have in contracts, and I can see in practice with my clients that they are rational economic agents as described by the science of economics, with nowadays the biases that we know from behavioral law and economics. So they're not purely rational, but they make trade-offs, and every time, for instance, during the pandemics, many clients wanted to know what would be the cost to get away from the contract, right? They were analyzing how to get away from some of them for real economic hardship. Let's say airports, if you lose 80% of your revenue, it's fair to think that some adjustment. But others, and I'm not saying who they are and if we file a lawsuit or not to rebalance the agreement, but others, like let's say in agribusiness, they could work. It was open, and why they would rebalance the agreement, right?
Right.
So, but I could see that, and sometimes I'm in one side, or sometimes I'm working in favor of the plaintiffs, other time for defendants, and I can see that plaintiff is an economic agent acting based on opportunism, which is for economists. Opportunism is something that is inherent. It's like, you cannot deny it's not an ethical problem, being opportunistic from an economic standpoint.
Yes, from an economic, there's this. I read it a long time ago. This article from Richard Posner. I know he's not the father, but we usually refer to him from when we speak about Chicago Law School, law and economics, and he has this piece. It is titled "Let's Not Blame a Contract Breacher." Let's not blame let's not blame, and because sometimes, or most of the times, the party who is breaching the contract is calculating. The party is actually weighing the advantages and disadvantages, because of course it has it has consequences, and it is based on the consequences that we act. So that, but and I think I'll put the link below here, below the our below the in the here in YouTube for those who are interested. And since we talked about and then we're going to develop a little bit more the paternalistic justice and versus the economic efficiency justice, because now looking at Article 421 of Brazil's Civil Code, that talks about the social function of contracts. In fact, it puts some limits on freedom to contract. And I think this is a very interesting discussion for us to have. So I wonder, how can legal actors strike a balance between protecting the economically weaker party, which is really at the heart of that idea, and still ensuring the kind of legal certainty and predictability that markets need to function well? So where do you think the law should draw that line between individual fairness and the broader economic good?
Yeah, I think the civil code, the considered new civil code from 2005 made, or the legislator made this choice in favor of principle standards like good faith, social function. At that time, I already thought it was a bad idea because it would, because I thought that this would be not good faith, that you have like a tradition of legal thinking and doctrine, but social function. I thought it would be a blank check for the judiciary.
Sort of a green light for courts to fill
judicial, And the problem is, due to a lack of economic background, and I think it's a long discussion, but I think by and large, humanities tend to lean to a more anti-liberal approach, and this was documented by Sunstein. Like in humanities, for each 10 professors, and every 10 professors in humanities in the US, 9 would be considered themselves Democrats and 1 Republican. So there's an important imbalance. And Pinker recently mentioned that. Pinker is a neuroscientist from Harvard, that Harvard should have more conservative teaching. And this lack of representation means also lack of market of ideas. And I think maybe Chicago was an exception and presented itself as something more Chicago school, right, in the 60s, because it's very different now, in favor of market. So I think in law in Brazil, and this is unfortunately not disclosed by professors, but they have a hindered ideological choice or bias. They don't disclose that because they just talk about, in theory, about dogmatic principles, but there are choices, unrevealed choices, and I think it's ends up by creating a dogmatic that is very paternalistic and not measuring the consequences. And the result of putting such a language like social function of contracts open the door
for misunderstanding, I would say, for misunderstanding.
Oh yeah, because
if you take it literally, because if we think about the case, the green soy case, back in the. Can you talk about that a little bit? Because there was this upfront investment and from traders to farmers.
Yeah, a relevant part of agribusiness in Brazil is privately financed by spontaneous agreements created by the market, the parties. And one of these agreements are the trader would pay in advance so that the farmer would have a protection over price variation in the market. So producers would know how much they would gain, so they can protect, they can hedge themselves, right? In an activity that is very subjected by or subjected to weather conditions, and it's very risky, right? So you can protect yourself, you can hedge yourself, and also you can have the funds, so you don't need to go to the bank. Banks charge a surplus, so if you avoid the bank, it tends to cost less to get the money. And so market developed this until courts in Goiás decided, in the name of the social function, to protect the farmer in a way that the farmer wouldn't need to render its production.
To deliver at the
goods.
agreement. Yes, because the agreement was the farmers get capital early, and the traders lock in the price. So it was a trade. So there was an exchange. There was consideration. If we take the consideration,
there was
right. So farmers get the capital early, and the traders lock in the price. But then courts came.
I would say that both are locking the price, because imagine that a farmer in Goiás wouldn't, because can a farmer be an speculator? He can. He cannot sell in advance, so he can speculate the price, because he will start to plant, and then he would harvest, and then he would go to the market 6 months after. Imagine that his cost is 5. And today the price is 10, but it can happen that there's an overproduction in the US, then the price would go to 3.
Falls to 3.
And then
he's safe at 5. He would be safe at 5. And who would complain? So
both would be protected, because then the trader would also hedge himself in the future.
In the future, that's true.
So everything is hedged in a way. So the court imbalance all the situation, trying to protect the farmer, being the supposedly weaker party. But we know that soy producers in the Brazilian Midwest, they're not vulnerable,
They're
weak
not weak.
guys, that would need a state protection. They could be responsible for the agreements by and large, right? And I think the courts of Goiás were very paternalistic. They changed the agreements, and that created a whole problem in the sector, and with a tendency to increase the cost of the finance for everybody.
Costs pass on, so it's not
Yeah,
that
somebody has to pay,
somebody
right?
has to pay.
And
Yes,
somebody has to pay. There's no free lunch, so the cost, the additional cost, would be included in the price for everybody, So, yeah, and then the Pensa, the Agribusiness Institute from FAIR at that time, made a research and to understand what happened in the market, and some traders stopped doing business in Goiás until the Superior Court of Justice solved the cases, and they solved the cases in favor of the trader. In favor of pacta sunt servanda, as we know, right?
Pacta sunt servanda. So,
and we have other cases right now, for instance, courts in the Brazilian Midwest, between commas, right? The Center West. Now they're deciding for the same blah, blah, blah reasons. Social justice, and there's always an excuse to interfere in the agreement, but in favor of the chicken producers, without taking into account the agreement itself, and in the case there was a expert witness from an economist showing the richness that the buyers, let's call the traders of poultry, right, in the region, and how the region became richer and more developed as a result of BRF, and even, well, the case analyzed BRF, but there are others that buy the production of poultry.
Yeah. So there was, so just for our viewers to understand. So there was about the interference there.
There are many agreements. They call integration contracts. That those companies, they organize the production of poultry, of eggs, and this kind of things. And there's this called integration way of organizing the production.
Right.
And courts, in some cases, some judges start saying, well, I don't think this contract between this big purchaser and this small producer is fair, so I want to nullify this clause and consider a breach, blah, blah, blah. And again, you have this paternalistic view favoring someone who is not exactly weak and deserves protection.
And apart from that, not only they are not the weaker party, strictly speaking, but the consequences of this judicial interference ripples through the market. So it can increase costs, increase the value or the price of goods. So it's not a win-win, definitely, for the market. And
no, it's not. No, it's not. I think you're right, and you capture perfectly what I wrote about, and I thinking of rewriting, that was also my PhD thesis, how agreements should be protected, and actually taking seriously what is social function, because if it's social function, you should social function is what society chooses to format, and you cannot deny the market as something that is a social artifact. And by saying that, I'm not saying that is perfect, but it exists, and so yeah, I think you're completely right, and there's a legal issue. The LINDIT, the Brazilian introduction law, obliges judges to consider the consequences when they apply principles.
Right.
And that's the room for us lawyers, and that's the thing. We cannot just blame judges for being paternalistic. It's the attorney's job to present the consequences and ask the judge to consider them. And then you would need to work with economists, accountants, engineers, and then we come back to the previous question that you make about that you pose about how to interact all those tools, and that's why I think that we must use those tools to win cases, because if you don't show the judge the consequence, then it's easier for a judge in a paternalistic society to simply follow the intuition, right? And not the data, the evidence, the economic rationale.
Yes, it's about bringing the empirical methods and economic analysis into the legal thinking, and this is our job, the lawyer's job.
Yeah, that's the thing. So, like at CADI, lawyers work with economists, and they utilize the tools of economics, and so it's a matter to adapt and work like lawyers do before CADI, so they could and before big cases, as you mentioned at the Supreme Court, consequences are always considered. Maybe it's not, of course, it's not the only thing that would be considered, but is one of them.
Right. Yes. And I would say this empirical research, and so we change from the abstract to the data-driven realities. So I think that's the most practical, and it's a mindset that should spread. So
yeah, it's like using jury metrics, that is the statistics applied to law. In some law schools, they are starting to teach that, and I think that's an advantage, and I think that's why companies, clients, law firms are really trying to hire people from those law schools, right? There are more, because some academics, they are in their ideological dream, manipulating students, but the reality
is completely different, and we all pay for that. So we are all approaching our closing here, but I would like to hear from you that drawing on your own path, both in academia and in high stakes legal practice, that's what you do. What key lessons would you share with law students and young lawyers who are hoping to build a stimulating career? Because today that's difficult, and we are living interesting times, to say the least. And was there any experience or a challenge early on that, looking back, you wish you'd understood better, or something that you could really help new generations starting out in the legal profession?
Yeah, I would have finished economics. I think it was a pity that for many reasons I haven't. So, but I think and that's what I tell students, try to study something else than law, like accountancy. Not to be the accountant, but to understand the language and being able to talk with the CFO, right? Of a company.
And being a little bit more open-minded.
Open-minded, yeah. And
right?
And also economics. And I would say nowadays, I think statistics, and nowadays, of course, learn to program. Not to program, not to be a developer, but to understand the language and to understand how to interact with computer science.
Yeah,
people.
That was something that certainly would make a difference. Yes,
and I met a guy at Miami University who is computer scientist and lawyer.
Oh my God. Oh my God. Oh, okay. We've had here Isaac Costa. He is from the MIT. I'm sorry, from ITA. I just confused. I just changed the country. So from ITA, he was interviewed by us here on the Global Law. He's a computer scientist, and but I as I always say to him, it's the one and first and one and only lawyer and computer scientist and computer engineer.
But in the US, you see more. I think that's why they are more advanced in legal. Because it's undeniable that in legal industry, US is leading. Maybe in car industry is India, is China. I don't.
China,
yeah, probably. In wine is France, but in but in law, I mean, we have to admit and keep saying that Germany is the best place for I mean, there's no one big German law firm that leads in our market. It's just keep saying that Argentinian wines are the best. They're not. They're in the international market. They're good wines, but we have to admit the reality of the legal industry.
Yeah, and there are also other components because as you said, in UK and in English, in the English law firms, for instance, that is a regulatory aspect that also contributes for law firms boosting there, and not in Germany. I don't know exactly what the law says in Germany about the regulation on law firms, but what I know is that they have more leeway in England and in the United States. So in terms of enterprise, law firms are better off in the common law system. So Professor Timm, so thank you so much for sharing such inspiring and insightful perspectives and on how we should be thinking about contract law. And this is a discussion that pervades our lives, and I think even because law is more and more interdisciplinary and interconnected with other fields of knowledge. So it was a real pleasure hearing you connect scholarship, doctrine, economics, and practical experience, and in such a meaningful way.
Marina, thank you and congratulations for your project. It's booming, and it's important that we Brazilians export our views. Yeah, and congratulations and thank you for the invitation.
Thank you so much. And to all of you watching, thank you for joining us today and for being part of the Global Lawyer community. Your presence here is what keeps these conversations alive and growing across borders. And I'll leave you with a thought that feels especially fitting for today's episode. Carl Llewellyn, a leading American legal scholar and a central figure in the School of Legal Realism, who popularized the distinction between law in books and law in action, once wrote that law is not a set of rules, but what officials do about disputes. And today's discussion showed just how vital that perspective remains for anyone working with contracts. So thank you all again for being with us, and I hope to see you in our next episode. Thank you again. Bye-bye.